Eleanor, and I want to thank Eleanor, Eileen and the team at Raise for inviting me here today. I've been away from the Assembly for 4 years, so this is the first time doing one of these, so I'm delighted to be here. And I'm also delighted that we've went for quality instead of quantity in the audience today. So I also want to make my apologies to Alice and to Eileen and Eleanor. I'm also on the PAC committee, and it starts at 2 o'clock and we have to squeeze in a pre-meeting beforehand. So it's no reflection of Alice's presentation. I'd love to be here for the presentation and the discussion afterwards. I'm just not able to do it on this occasion. So please accept my apologies on that. I'm here today as Deputy Chair of the Committee for Communities, as Eleanor has said, and I want to welcome all of you here to today's seminar. I'd also like to extend my appreciation to Dr. Alice Diver, who will present her research findings regarding an examination of recent case law, wherein issues relating to welfare reform, housing and human rights are addressed. It's a very interesting case. It also brings in the whole issue of kinship care and the pressures faced by kinship carers, another issue that I'm very interested in. So I'm particularly sorry I can't be here, but I'll make sure and check out the video afterwards. Welfare reform, housing, human rights, they're all issues of interest to the new Committee for Communities, and housing is a very high priority for the committee, and we're well aware that many challenges lie ahead in this particular area. For example, in the context of homelessness, an issue that has been on our TV screens recently as well. The latest 2015-16 statistics state 18,628 households presented to the Housing Executive as homeless, and 11,202 of those were accepted as full-duty applicants. These statistics do raise serious issues, posing questions about what needs to be done in terms of building necessary accommodation, also about pressing issues relating to housing standards, and both require money to make them happen. A recent assessment by Savills of the Housing Executive stock established that an investment of 1.5 billion is required over the next 5 years to raise the standards of all NIHE properties to the commonly adopted standard. But that money obviously can't be realised from current rental incomes alone. And I'll try and put that figure into context. Here in the North, the total departmental expenditure limit, or DEL, budget for 2016-17 is just over 1 billion. And we're talking about all of that and half of it again. The Savills report did recommend increased rental income and capital investment as means to fund the 1.5 billion investment it states is needed. The rental income one is probably quite controversial because the people who live in a lot of the housing stock are on either low wage, they're often relying on either benefits or top-up benefits. There are people who are working full-time who don't apply, aren't entitled to any benefits, who are on maybe working 40 hours a week, minimum wage. So rent is a big issue. Fuel poverty is also high here in the North. So we have to look at what is achievable with our tenants. But obviously, if the requirement level in housing stock isn't met, the Housing Executive standards will be impacted. We won't be in a position to deliver maintenance and repairs at the required level. In fact, even now, it's hard to get necessary maintenance carried out to Housing Executive properties, and we will see our Housing Executive social sector housing fall into further disrepair. And it clearly isn't fair that either by luck or by timing, the people find themselves in either a good standard of social accommodation, while others have to make do with a substandard home and just be glad that they have a roof over their head at all. So today's seminar will hopefully help to inform how to strike appropriate balances when individuals seek to access an appropriate standard of housing that there isn't money to build or repair or maintain homes. Housing, as you're aware, is allocated on the basis of need, as are maintenance, response maintenance and plant maintenance and repairs. There are checks and balances built into the relevant processes to address the potential for inequity and unequal treatment. One of the reasons the Housing Executive was established in the first place was to deal with discrimination in housing. And politics has often been described as the art of the possible. In these current times of austerity, maybe a more appropriate description is offered by J.K. Galbraith, a renowned American economist and diplomat who advised a number of presidents in the United States, including JFK. who once stated in a letter to him that politics is the art of choosing between the disastrous and the unpalatable. Well, I think it's our challenge to find another term to describe that, because I suppose welfare reform would have been disastrous. We tried to find a way to make it more palatable and to find something in between. And I think the actions, therefore, that we've seen by the executive, particularly in relation to welfare reforms, highlight this. In recent weeks, the Committee for Communities has considered subordinate legislation that empowers the Department to implement some of the welfare reform mitigation measures recommended by the Welfare Reform Mitigations Group, as led by Professor Eileen Evison. They do cost money, but they also provide support, admittedly time limited, for those who are most vulnerable. Support that we had to negotiate really hard for from the British Government. In the last mandate, when the Assembly's former Social Development Committee Reform Bill scrutinised the Welfare Reform Bill, it became apparent very early on that applying the bedroom tax would create considerable and devastating hardship for vulnerable and low-income households. We don't have sufficient or appropriate housing stock to facilitate the application of the bedroom tax here. We just don't. We don't have enough two-bedroom, one-bedroom units to accommodate people. Crucially, one of the measures suggested that by Professor Evison's group and agreed by the Executive is that funding will be provided to mitigate the application of the bedroom tax here. This is a very significant development, and in the autumn the Committee is to consider subordinate legislation seeking to implement this commitment. It's important not to underestimate the effort that's gone into negotiating the mitigation measures and the additional flexibilities that are to be applied here in the North. An example is the continuation of the payment of housing benefit directly to the landlord rather than to the tenant. But despite these mitigation measures, the Committee aren't taking our eye off the ball with regards to the outcome of court cases in England and Wales relating to the application of the bedroom tax and discretionary housing payment rules. Cognizance must be taken of the potential implications arising from the judicial decisions on social security related case law and decision making here. And these cases bring further into question the impact of austerity measures on human rights. They go to the essence of human dignity, raising highly emotive issues. And Alice is going to talk about the Rutherford case. I suppose one of those cases that you just could be in any town, anywhere, could be any of us involved in it, but the impact on the human rights of the people in this case, you'll see, are not only emotive, but they're the reason that we do what we do. They're the reason that we're here. All of us are here today to try and find ways of ensuring that outcomes like this don't happen here. So I'm going to hand over to Alice. I know you'll have a very informative seminar. Again, I'm sorry, Alice, I can't stay, but I look forward to seeing it back on tape. And thanks everybody for coming, and enjoy the seminar. Gur míle maith agam.
Okay, thank you, Michelle, for the kind comments, and I should thank Eileen and Eleanor as well for inviting me along today. Okay, bear with me with the... It's better. Okay, basically what I'm going to be talking about is recent cases on bedroom tax that have come through the England and Wales court system with a view to finding something relevant to the Northern Ireland situation. Recent UN jurisprudence is in there as well. It'll come in, we'll talk about that near the end because it's a bit more uplifting than maybe some of the cases. What I thought was quite interesting about them was what the courts are doing in relation to discrimination, in defining it and in defining justifiable discrimination. It's just interesting to see the way that they do that. It came out of it sounds quite narrow, but it was part of a wider project, slight book plug, wider project that looked at rights in general, about how you get paper rights, international law, bring them home and embed them meaningfully at the domestic level if you don't have any money. Now, that would have been a very unwieldy title for the book, but it went out as a call for papers. What came back was a lot of papers on housing, health, children's rights, all pretty much bound together by equality, or more accurately, inequality, and the need for human dignity and non-discrimination. So of the 19 authors, I would say we're probably all broadly agreed that if you don't have the money, you're in bother. It's going to be very difficult to make these rights meaningful. Okay, the first bit, the torturous bit, is just to go briefly through bedroom tax. I know I've got housing people, so you'll know about this, you'll be familiar with it. But just to give a brief recap of what it is, where it came from, this notion of the bedroom tax. Some people call it the spare room subsidy. The policy documents from 2013 the government had out are worth a read, and I've got links to them. If you want to torture yourselves, you can feel free to read through those. The aim of it, well, it was in with the austerity measures, obviously. The aim was to reduce welfare payments and to encourage people to find work. And I'll try and stay neutral. Largely affects people claiming housing benefit. It can be people who are purely on benefits. It can be people who are also working. Disabled people have featured largely in the litigation. Under occupation or too many bedrooms. It's the notion that you have a spare room. Why should this be funded by the taxpayer? Examples, people who've been hit, you could have the single person in a 2-bedroom flat. You could have the small family, 2 children with a 3-bedroom house. The thinking is if they're young enough, they can share a room. The thinking is young people can share accommodation. This is the thinking behind it. You'll have heard of the discretionary housing payment. We'll call it DHP for short. The get-out clause is the discretion. It's not an automatic payment. It doesn't come to you for life. You must apply for it. In England, it was the local authorities, councils, who would decide on the payment of this. It was basically to make up the shortfall. If you had the spare room, your rent could be cut by 14%. 2 spare rooms, lap of luxury, 25% cut. So these DHPs should help you make up the shortfall if you're entitled to one. This is where the cases come out of. People have been taking judicial reviews to the High Court to challenge a non-award. Okay. Oh, again, yeah, just some of the policy documents. They talk about you could maybe take in a lodger. That's interesting because you might be in breach of your tenancy if you do that, especially if you're private sector. Moving to premises with fewer bedrooms. Again, you're probably familiar with this, but there have been cases of people having to leave London and go as far north as Durham or Newcastle to get an affordable rent. I'll be slightly contentious. If this was to happen in a conflict situation, you would call it displacement from land and property. But I'll let you draw your own conclusions. Recent case law, to give a bit of hope. The European Convention, obviously, is being referred to in great detail. You would expect Article 8 to be there. It's the right to respect for home, family, and private life. Article 14 is getting a bit of a starring role, the non-discrimination right. It has to be tied to another, so it's traditionally tied to Article 8. Article 6 is getting a look in as well, fair hearing, process, right of appeal. So you'll hear about this in some of the cases. Article 1 of the first protocol, deprivation of property, of possessions. This is an interesting one. Some of the cases coming from Europe. Can a welfare benefit be deemed a possession and be deemed a property that you can't be, a piece of property that you shouldn't be deprived of? Again, we'll come back to that. Best interests of the child, thankfully, starting to get a bit more of a mention. And I say the wider project looked at health and at childhood and at various other rights. So you know yourselves, housing people, it's not just about there is a flat, there is a roof over your head. It's about all the other associated aspects of human dignity that sit with it. The burn-up case, you'll hear about burn-up categories towards the end as well. Burn-up was a good case. The Court of Appeal basically said this policy, our dreaded B13, sometimes called 13B to keep us on our toes. You'll find it in different court cases, different academics. They said it was unlawful discrimination. Great. This was, a positive case. It affected certain categories of people in particular. They fell through the safety net. If you were an adult who needed a spare room for your overnight carer, if you were a child and maybe had a disabled sibling, you can't share that room at night because you won't get any sleep, etc. These directly engaged Articles 14 and 8 of the European Convention. The result of burn-up, regulations were changed. More policy guidance came out and a bit more money was made available. Right? It was a good case. 2 steps forward, 1 step back. It was followed 2 years later by the MA case. Not so good a result. Again, the court talked a lot about unlawful discrimination and when can you justify it. So this is what they really focused at. It's a lengthy judgment, but it's worth a read. Right? If you have a spite at yourself, but it is worth a read just to see what they do with the definition and how it works. They've given us sort of a definition for justified discrimination. It must be manifestly without reasonable foundation. You might think, very clear. How long is a piece of string? It's clear. They go on then to pad that out a wee bit. If there's no objective and reasonable justification, then this will be unlawful. And at this point, I thought this may differ slightly from your slides, so I apologize. They will get, I've put in 1 or 2 extra for added value, and the proper slides will go up as well. But I just added in 1 or 2. I thought I was a bit fed up with the formal phrases. I thought, no, with a nod to one of the claimants in MA, to Mrs. Carmichael, I'm not going to read that out. You don't want death by PowerPoint, but I'll let you have a read at it. Basically, she and her husband, they can't share a bed. They can't share a room. It's a small place. They're not going to fit another bed in. But is the decision, are they being told by this policy that they can simply share that bed? Well, you're a married couple, so therefore we assume you'll care for your wife and that this is acceptable. So I'll let you read that and ponder that. Some slight good things to come out of the case. At least they noted that disability needs can vary greatly, yes. The regulations will address the needs of some people, and for others, in theory, the discretionary payments should address the other needs. That is the theory. In this case, why it's annoying, the court said actually that this discrimination is justified. I don't want to keep saying austerity measures, but arguably that was the bottom line, that the fund had been used up for that year. This case is on appeal to the Supreme Court along with Rutherford. Rutherford, I'm going to time travel back slightly so you can see its journey from the High Court up to the Supreme Court where it now is, and where hopefully the decision will be delivered very soon. With Rutherford, this was the category that didn't fall within burn-up. Right? So it's a gradual, I don't want to say cherry picking, a gradual sorting out of burn-up categories. Here you have disabled child needing overnight care. If it sounds familiar, it made the news earlier this year when it got to the Court of Appeal stage, because the Court of Appeal overturned the High Court. The High Court basically said, okay, you've got this 3rd bedroom, and the respite carer will stay over twice a week, etc. You're storing your medical equipment there. They looked to see, they spent some time discussing whether there is a difference between adults and children needing overnight care. So they talk about that, they talk about the best interests of the child. The fact that you have to apply for discretionary help, it's going to feature more now in the upcoming case, what the Supreme Court is going to say. The uncertainty of that, example, domestic violence victims, not knowing if your award will be repeated in 6 months' time. The fair process, remember Article 6, if you don't have an automatic right of appeal, but must apply for leave to seek judicial review within your 12-week time limit, having to do that, where's the right to a remedy there if it's not automatic? Anyway, it's good to see that these were being discussed. However, what it came down to at the High Court stage, margin of appreciation, and my students call this wiggle room, which is a far better way than I can ever describe it. Basically, you've got the European Court saying, we'll leave that up to you, member state. We'll let you interpret that in the way that you want. There's quite a few things fall into it and are forever lost. It's, again, down to more discretion. So this arguably is an area, if it's a socio-economic right, it's your budget, I think is what they're saying, so maybe you can define it the way that best suits you. Interesting thing they said in the case as well, it's not enough just to show that a law is flawed. That will not make it illegal discrimination, unlawful discrimination. It has to be seriously flawed. I would urge you to read the judgment, it's interesting. And the effect needs to be unreasonably discriminatory. Right? So if you're going to mess up badly, I think is maybe what they're saying. The key issue that really came out from this, they hadn't shown the magic words. They hadn't hit the level of manifestly without reasonable foundation. Other things that the court pointed out, why Rutherford didn't go well at the High Court. They said, well, more funding was made available, the policy changed, and here's the killer punch, and I've highlighted this. There's extreme financial austerity. So this was 2014. And because just in case we didn't notice the recession, they pointed this out. So it's a bit of a, I know I sound cynical, bit of a serious get-out clause for the funders and the decision makers. They also made the point that the government wasn't being irrational. Some aspects of, that's my own words, less than ideal. Some aspects of the scheme weren't particularly fabulous, but it wasn't enough to knock the whole thing out as unjustified. So it went then to the Court of Appeal earlier this year. It made the main news. You may have seen it. It was hard to watch. Very, very disabled people. Just a tough decision, but one that was the Court of Appeal. Yes, it was heard along with. It was broadened out slightly, in that it was heard together with a lady who was the victim of domestic violence. I have actually brought a copy of the case. Don't all rush at once, but if anybody wants to have a read at it, I've brought it. And again, I made my students research, and it made them angry. That was good. Angry students, a good thing. Burnup came back. They said, yeah, we like the Burnup decision. We shall endorse this. This is a good thing. Does it mean that Regulation B13 was unlawful? If you're looking at your categories for Burnup, is vulnerability the new test or the new word? Arguably after this, yes. They tied it to the public sector equality duty. So if there are any local councillors or MLAs listening, bear this in mind. I know the 2010 Act doesn't apply here, but we would have things that are similar. And the duty's worth looking at, all right? It's not asking you to be Batman, but it's placing more of a burden on you than to just do your best. So look at this. You have to have due regard to the need to eliminate discrimination, harassment, victimization. Now, due regard, it doesn't mean just read things and say, we'll try. It doesn't seem to be just as aspirational. Remove or minimize disadvantage. Equality of opportunity, something you would have heard a lot of in 1998. Key human rights principles getting sort of fed in there. Take steps to meet need. This is the court sticking its neck out a little, in my humble opinion, and saying, look, this is not good. It's not going well. If you're a policymaker, this is maybe what you should be thinking. If you're a decision maker in charge of one of the funds, having to give out the money. If you're going to discriminate, can you say you've got objective and reasonable justification? And then again, back to the magic words of manifestly without reasonable. They warned, and it's master of the rolls, when he gives you, when you're warned by the master of the rolls, you want to pay attention. The courts will scrutinize the reasons that decision makers are giving. That is serious throwing down of gauntlet. If you've got differences in treatment, be very careful. And I like this. It's not enough for you to have a vague awareness of what your legal duties are. You need to have focused awareness. Legislation is going to have to be read in great detail. This is no bad thing. Potential impact is another one. It's not enough to say, here's what happened, or that will never happen. They need to really think. If you don't get this funding in 6 months' time, you could have the threat of homelessness. If this decision, if moving you to a one-bedroom flat means that at weekends you'll no longer see your child under a contact order, that's potential impact. So it's quite forward-thinking. They pointed out gender-based violence in respect of the domestic violence case. What happened? The government, I think panicked is not too strong a word. Basically, they appealed. It's now with the Supreme, very fast. Now with the Supreme Court, a decision is awaited. I've given you a link if you want to engage in watching for it as well, and I'll give you that link at the end. What can one expect from the decision? Hopefully, international law will feature. It's not binding, it's only persuasive guidance, but it would be nice if they could be guided and persuaded by some of the provisions that I'll take you through. Will justification be defined again differently? Maybe. They seem to be liking the word. It's getting a lot of attention. The Equality and Human Rights Commission in England has made submissions, so they will have to be addressed. Other key issues, well, it's coming down to the Court of Appeal. Did they err in law? Burn-up categories, are they possibly going to change? And again, best interests of the child creeping in. Could these regulations seriously be in breach of best interests? I'd like to see that, but we'll see. Not to get too excited, I found a case from 2013. It's only High Court, but I wanted to share it with you because of the language that's used, because it looks a bit more widely. It was community care rather than straightforward housing. It was a young man coming of age. His mother was also dying of cancer. He was basically facing a funding cut in his package of community support, leaving him with the choice of take the reduced funding or go live in residential accommodation, neither of which he wanted to do. Some of the things that the court said, again, in case we hadn't noticed, these are times of considerable financial stringency. They pointed out that consultation is key. They looked back to policy documents for the past 15 years. They talk about the need for choice, individual planning. They do at least look to Article 19 of the UN Convention on the Rights of Persons with Disability. Good. They point out that you should have access to a range of support services. So it's a little bit, there's some hope there. However, they then look at case law right back to 97, and the conclusion, the public purse is not bottomless. So it wasn't going to go well. It didn't go well. It wasn't a great case. As far as I'm aware, it's not been appealed, but just to give extra context. International law, I'm not going to take you through everything that talks about welfare and benefits. These are just maybe some of the highlights. The International Covenant on Economic, Social, Cultural Rights, you can have a look at Article 11 is longer than that because I know that there's football on later. But if you note the way they set it out, adequate food, clothing, and housing. Defining adequate has been problematic, getting people to agree on what is adequate. The Children's Convention, at Article 27, it pops up again. State parties, you're meant to provide material assistance and support, particularly in respect of nutrition, clothing, and housing. And I'm glad they've got nutrition. I'm not going to talk about food banks because we'll get angrier. If you look to when the UN committee do country reports, and they do it now and again, you get a telling off. Sometimes it makes the news, sometimes not so much. But once you know they're out there, they make for good reading. As far back as 1990, they talked about your obligations and how you'll be failing at them. You've signed up to this convention. Please behave. If there's a significant number, is an odd one because you wonder how many people does that have to take. Is it okay if one person dies of hunger or what are we looking at? But again, basic shelter and housing. So if you want to be guided, if you're a decision maker, a legislator, you'll find useful guidance in these. Some of them talk about resource constraints, aspirational goals. The concluding observations are good as well. This is where you will get the telling off. The Convention for the Elimination of Racial Discrimination reminds us about migrants. Don't forget about Indigenous communities. Don't forget about migrants and refugees. Again, you've had Croatia, Jamaica. They have been sort of singled out, criticized, and said, look, don't forget universal coverage. Try not to leave groups out. The disadvantaged, the marginalized. Are they going so far as to say ring fence the money? Not quite, but they are saying about the need to prioritize. And that's what there's another chapter in the book that talks about ring fencing. It says maybe rights is not the way to proceed. Maybe you need to look at this as if it's nearly on a trust level, and that the only way to do things is to ring fence, because rights are maybe a bit too fluid. Again, yes, Estonia, decent standard of living, and you'll hear about decency again when I come to the end. Again, Brazil, highlighting the needs. A few cases, and these aren't I'm not sure if these are on your slides or not. Not going into a lot of detail on them. But they're interesting. What's coming from the European Court of Human Rights, what's coming out of Strasbourg, again, not binding, only persuasive. Please be persuaded. In a Russian case, it wasn't just about housing. It was about a man living in a basement, no heat, no hot water. They were ordered to rehouse him. The delay took so long, he died, and his wife ended up having to take the case. But you had Article 6 and Article 13 being mentioned. So it's about your fair hearing and about process. If you were to be guided by this, you would say, well, we can't just let delay solve the issues. The UK case, the Ali case, this was a lady who was offered 2 premises, and she turned them both down. She wasn't written to about the second one. The case went to Europe. It's interesting because the court said, on the whole, the UK is compliant don't tell the special rapporteur, as she was horrified a few years ago about bedroom tax. They said, on the whole, you know, you're compliant. However, this is the interesting bit. They stuck their necks out. They said housing, not so much a social right anymore, not so much a qualified thing. It's actually a civil right. That should be cause for some hope, if not outright jubilation. The French case, I wanted to tell you just briefly about them. They have a 2007 Act that enshrines the right to decent housing, not adequate, but decent and independent. Again, it was a rehousing case, and I like what they said. You can't just plead lack of finance. So, you know, whether that's a warning salvo over to the UK or not, I'll leave it to you to decide. The Article 1 of the first protocol, I mentioned at the start, the right to hold a lease, to be a social tenant. Can that be a possession? Can it be something that you should not be deprived of? The answer's not yet. This case said no, it's not that kind of possession. It won't fall within Article 1, Protocol 1. Although somebody sent me a case about fishing rights covering Article 1, which that's my entertainment for tonight. I'll have a look at that. I'm not holding out a lot of hope. Again, some useful links if you've been hooked by this, and it's opening up new world. These are, you can keep up to date with Rutherford. The country reports, that's a database that's quite useful because it does it by theme. And again, the Strasbourg cases. So I can get those out to you. And I would say thank you for listening.